Okay, welcome. Apologies for the delay. Will not stick around. I'm Monatea. I'm director of the Institute for Middle East Studies, and we are delighted today to be joined by Alexandre Caeiro and Dr. Nathan Brown as well from GW. So I'm going to introduce the two of them, and then our associate director, Shana Marshall, will be in charge of moderating for questions, which you can put in the chat. So I'd also, before we get started, want to just thank Christian Clinton and Elad Raymond for all the work they do to make these events possible. So Dr. Caeiro is associate professor at the College of Islamic Studies at Hamad bin Khalifa University. He was trained as a sociologist and also in Islamic studies in France, the Netherlands, and Egypt. And his research deals broadly with the transformation of Islamic law in modern contexts. His work is about the legal history of Gulf sheikdoms, focusing on the interaction between emirs, Sharia judges, merchants, and British agents in the context of the development of an oil economy and modern state institutions. He'll be basically interviewed by Dr. Nathan Brown, who's professor of political science and international affairs here at GW, and was the director of this institute before I was. His research focuses on religion and politics, authoritarianism, constitutionalism, and comparative judicial politics. He's the author of numerous books, but most recently Arguing Islam After the Revival of Arab Politics. And he's the recipient of numerous awards, including the Trachtenberg Award for Teaching and the Harry Harding Award also for teaching. He was president of MESA and is a non-resident senior fellow at the Carnegie Endowment for International Peace. Thank you to both for joining us today. And I will pass the floor over.
Okay, thank you very much, Mona. I don't know if everybody else's internet connection is as glitchy as mine, but when I heard you introduce our guest, the Caeiro was really emphasized, perhaps to distinguish him from the city of Cairo. But it's just a real treat to have him here with us today. For me, a personal treat. Now, all I would say, a decade and a half, maybe longer. And what I've always liked about it is that he asks questions that I want to ask, in fact, that I do ask, but can't answer. And then he goes ahead and answers them. And that's actually where I want to start the dialogue. So you're working on legal and judicial history of the Gulf. And this was a topic that I'd done some work on really longer ago than I care to remember. I began working on it early 90s, and I found it just an absolutely fascinating field in all kinds of ways. But I also remember getting there and getting to, for instance, in Doha in 1994, and just think, I'm here too late. It's gone. This cannot be done. And yes, there are some British archival records. Yes, there are some historical memories. Right, when I talk to people, they'll talk about things like, well, the ruler's court or the merchant's courts or the old Sharia courts. But basically, there was very little documentary evidence available, and most of the people who were involved in these were either extremely old or had already passed on to the next world. So I just thought this couldn't be done. This is over. I'm sorry, I'm too late. And that's what you're doing. That's what you're offering. So my first question is just basically just a how. How is it that you manage to uncover legal history of a region that seemed to me, admittedly a political scientist, not a historian, but seemed to me to really kind of challenge a historian's ability to even a clever historian to uncover this sort of a documentary trail for a world that seems in some ways to have passed from the scene or transformed into unrecognized.
Well, thank you so much, Nathan, and thank you everyone at George Washington University for the invitation. I'm I'm presenting work in progress today, and so it's a real opportunity, a real treat for me to exchange some ideas with you, and particularly Nathan, your work has been an eye opener for me. Your book on the rule of law in the Arab world, I think from 1997, made a number of claims or suggestions that were really the starting point for my current project. The first suggestion was the idea that Sharia law actually had a limited scope in the Gulf Sheikhdoms before the establishment of modern state institutions in the second half of the 20th century. And secondly, that there is a potential of the Sharia judiciary, particularly in places like Qatar, you suggested, to act as a check on political authoritarianism in ways that civil courts were unable to do. And so these two suggestions or arguments that you offered have led, well, the second one, rather, for a more focused study on Qatar's Islamic institutions, in particular the presidency of Sharia courts and the judges and muftis that worked in it in the second half of the 20th century. The first claim about the limited scope of Sharia and the fact that there was actually a range of courts, including commercial courts, emirs courts, tribal modes of dispute resolution, has set me on this path to know more and to think about what other legal structures were available. And the pearl trade provides the richest archive to think about this issue, right? And to think about the relationship between customary Islamic and state laws in the Gulf. I guess the common figure between these two projects is Sheikh Abdullah bin Zayed Al Mahmoud, this long-standing Qadi of Qatar, a Saudi, a Najdi of origin, but who came to Qatar in 1939 and was the chief judge who presided the presidency of Sharia courts until the late 1990s, and who in his career seems to have only issued one fatwa on pearling, on diverse ritual obligations, which precisely highlights, I think, the differentiation of courts and legal forums that you are hinting at in your work. The fact that muftis and qadis were seldom concerned, seemingly, with the pearl trade, seemingly the pearl trade, which was the most important occupation and source of income of the sheikhdoms until oil. So how do I do this? Well, I mean, your work also demonstrated one thing very clearly, that it is possible to look at the British archives for information about how the British attempted to reform the legal structures of the Gulf, and also to evaluate the successes and failures of these reforms. Right? So British archives are very fruitful. I am particularly fortunate, I guess, because I live in an age when a lot of these archives are available in digital format, thanks to Qatar National Library and other such initiatives. And so I've also gone to London, to Kew Gardens, and to the British Library to look up some of the legal material there. But these archives are useful, and they're particularly useful because since the 19th century, the British sought to work through and within indigenous political and legal institutions. And so they, well, not only they monitored the legal field and watched over the ways in which legal actors solved cases, but they also very often sat in these courts, right? And sometimes adjudicated cases. I mean, this is particularly true in relation to the pearl trade in the 1920s and 30s, when Charles Belgrave, of all people, was often the person who was issuing decisions in the Khalifa courts or in the diving courts, while the emir went on hunting trips. And while the merchants who used to sit in these legal forums seem to be busy with other concerns and other pursuits. So the British archives are the first source, and there's a lot of material there, even for the late 19th century and early 20th century, that is very valuable. A lot of it is fragmentary, and we can discuss, I mean, I'd be happy to discuss later about the scope and limits of these archives, but that's the first source I guess we have. The second source is local historiography. And so my choice of pearling was also linked to the fact that there is a ready availability of Arabic histories on pearling. And these histories are based on oral accounts. Some of them were written, I mean, the first, there are historical chronicles in the beginning of the 20th century that talk about pearling. There are pearling histories that start to come out in the 70s. Some of them have been written already in the 50s, like Saif Marzouk Shamlan's famous history of pearling in Kuwait and in the Gulf. And they draw substantially on interviews with pearling actors, right? So oral histories to us are available, a lot of them available in print, because the local historiography of pearling has been based primarily on these local histories. These local histories are also interesting as a counterpoint to British sources, because they tell us, or they give us, a very different picture of pearling in general and of pearling laws in particular. And so you get to know much more about the social context in which pearling actors operated, about the cultural universe of pearling in the Sheikhdoms. And also you learn about Khalifa judges. I haven't spoken so much about Khalifa judges yet, but these were the judges who officiated in the diving courts. They are often caricatured in the British archives. They are seen as corrupt because Khalifa judges were part of the pearl merchant class, right? And so the British often identify the conflict of interest, settled cases at the expense primarily of divers, according to British sources. Now, this is the only information that we find in the British records. The local histories, and these include histories of pearling, but also histories of mosques and histories of education, refer to these Khalifa judges in much more detail, right? And so you learn a lot about their biographies, where they were trained, what they were known for, what they did for the community. And the fact that information about them is available partly in histories of mosques in local places or in histories of modern education initiatives already tells you something about the social networks of these Khalifa judges. They were pearl merchants who were often quite successful, quite pious, and so they were part of the patronage relations that sustained the ulama class in the Gulf, that built mosques and institutions, and patrons of the first schools also that opened up in the 20th century. Okay, so this is I guess, the second archive. There's also a rich set of Islamic texts, right? We have fiqh manuals, sermons, fatwa collections, correspondence between qadis and notables, qadis and rulers, qadis and or muftis and other scholars outside. And some of these discussions deal with legal questions, right? There are also a lot of theological debates going on. I mean, we have to remember that the late 19th and early 20th century are very lively periods, right, for renewed debates about Islamic practice, Islamic reform, and so on. And so local scholars here, as always, as everywhere, they produce textually dense archives, right? And these texts are available to us. Okay, so British archives, local histories, and Islamic scholarship. What they also offer to us is actually quite a bit of documentary evidence about the pearl trade, right? So in the British archives, you have manumission certificates and decisions of the Khalifa courts when the British agents were part of those institutions. You have letters exchanged between the political agent in Bahrain and the various rulers across the Sheikhdoms, right? Some of these dealing with legal issues because law featured very prominently in the way the British sought to intervene and regulate life in the Sheikhdoms. So documentary evidence from the British archives is available. Documentary evidence is also available in these local pearling histories in Arabic. So you have contracts, you have letters from merchants, you have certificates. You have all sorts of material, and often material that is not fully analyzed, but is available there for discussion, right? And for further analysis. There is also a genre, in Arabic, people refer to this as the dirasat wathaiqiyya, documentary studies, right? Where volumes about judges or Sharia scholars are published that contain a very brief description of the life and works of this judge, and then contain hundreds of pages with documents, letters, court decisions, fatwas, right? That are not analyzed. These are also being published, and these are also being made available for researchers. Now, in addition to this, so documentary evidence is available in these three different genres, in these three different sources: British archives, local histories, and Islamic scholarship. It is also available within families, in private libraries, and in difficult to access public archives. And so I guess by virtue of being here, I've been able to tap into some of these archives. There's much more than can be done. There's much more that could be done in the future, because although the legal field was weakly institutionalized, and although there are no really strong court records as you might find elsewhere, there are a lot of material for legal histories of the Gulf that remain in private hands, right? And it depends on our ability to establish relationships with those families.
All right. Thank you very much. I do notice among our guests, we've got several very good historians. So I'm going to leave the follow-up questions about archives and historical methods to them. But there's one other thing that struck me that I wanted to ask you about. So you mentioned my book, right? And the subtitle of my book refers to the Arab states of the Gulf. And I listened to you, and you do not use the word state once, right? You do talk about sheikhdoms, but you talk about local communities. And you get into this. And in fact, the way we got so many people to attend today was to talk about purling, okay, an area of law that I was going to say it's transnational, but even the term transnational is almost anachronistic in this context. So could you tell us a little bit about why did you decided to, when I was working on this, I was starting from the present, going back, okay, what is the Qatari legal system? How was it built, and how did it get to be that way? And starting from current states and looking backwards. But you start with purling in area law, and I wonder if you could tell us sort of why you did that, and what you think that helps us see that would be invisible to the state-centric perspective that I was perhaps a little bit too guilty of.
Yes, yeah. So that's an important question. For me, there are many histories of Islamic law in the Arabian Peninsula, right, that assume this state-centric perspective. In my work, I've been, as you know, I've been particularly interested in studying the work of muftis and the fatwas, and using fatwas as sources for a kind of social, economic, political history. And I think my sensitivity to the work of the muftis already pushed me to think beyond state lines, right? Because muftis always operate within more interstitial spaces. And when it comes to histories of Islamic law or histories of law in the Gulf and in the Arabian Peninsula in general, I think the focus has been on the relationship between religious and political institutions, right? Purling provided perhaps an alternative approach, one where we looked at economic practices as an entry point into these broader questions of law and political organization. Now, purling, of course, almost precludes adopting a national perspective or a state-based perspective, because in the time period that is my concern here, from 1860s to 1950s, there are local purling communities, right, that are dependent upon local rulers, and local rulers are an important legal actor in the pearl trade. Right? But the pearl trade was very, was regionally integrated. It was the pearling actors were mobile, right? And so you see even in the British archives clearly how divers, but also boat captains and pearl merchants moved swiftly from one sheikhdom to another, right? In order to engage in trade, in order to engage in pearling, sometimes as a mode of kind of political descent, because the migration of a tribe was one of the ways in which the political power of rulers could be undermined. And so the mobility of pearling actors was one factor that prevented me from speaking about state institutions. And the second factor was that state institutions, I mean, even rulers' courts are very, very weak. And so in the British archives, they always refer to them as courts, but these are very weakly institutionalized legal forums. And the ability of rulers in a kind of tribal setting to actually govern is really an open question. There is, I guess, suggestions in the literature that one of the distinguishing features of rulers was their ability to enforce laws. But even that, I think, was quite relative until the British decided to empower state actors and to promote a more modern understanding of political sovereignty. I think even the ability of the ruler to control or enforce a legal decision was quite limited. So the state, I don't think, is the relevant framing for the kinds of legal and political dynamics that I want to get at. Now, I talk about the Gulf, I guess, and I use sometimes Arabian Gulf because most of my sources come from the Arabian side of the Persian Gulf, right? I talk about the Gulf, but of course, there's this transregional dimension, and I think a number of works even that have dealt with pearling and other economic practices have very productively thought about the Gulf Sheikhdoms in this transregional context of the Indian Ocean. That's one direction to go. Also. And then there's also a pragmatic reason or a practical reason. So there's so little about law and legal regulation of pearling in detail that we still are not able to write local histories of pearling. I think we are forced to think about pearling in this regional perspective, partly because of this availability or lack of availability of sources that would allow us to tell very detailed local histories. For empirical reasons, because of the mobility of pearling actors and the regional integration of the pearl trade, especially under the British colonial power, and conceptually because the state is not such a meaningful agent during the time period under analysis. I hope that answers.
There's one question I want to ask you that's actually just based on my own personal curiosity, and so I know there are other questions out there for you, so I don't want to monopolize the question, but I just have to ask you about a particular figure who comes up in your written work and who you just mentioned, and that's Abdullah al-Mahmoud. So when I was working on this, I believe he was still alive, but I'm not sure he was active in any kind of way. But he was definitely remembered. He was a huge presence. He was kind of the judges that I would talk to who were in the non-Sharia courts, what we called the Adliya courts, remembered him as kind of this crusty old guy who'd resisted their work, even referred to them because they were not Sharia-based courts as the courts of Satan. So if he was still alive, I never was able to get an interview with him. I do remember meeting his son, who was a legal advisor for the Qatari Islamic Bank. I think another son is now Speaker of the Assembly, if that's right. And his name is on a major mosque in Doha, right? So he's an interesting figure, kind of in I would guess the legal and religious history of the Gulf. And when you mentioned him here, it was almost, he was sort of marginal to use only one fatwa, you say, on pearling. And you also mentioned that he's when you first identified him, you called him a Saudi, whereas the figure that I encountered, not physically, but when people would describe him, it was as kind of this towering figure in establishing Qatari institutions. So that's all just by way of background. I wonder if you could just reflect a little bit about what focusing on individual trajectories, or in this case, even kind of a family, can be helpful. How following a figure like this, who seems so central, but to appear in I guess very, very different from different angles, what it can tell us about the history of religion or of law, or just even broader social histories and political histories of these locations.
Yes. So thank you for that question. I mean, I think so that bridges both of my current projects, the one on Perling and the one that comes afterwards, thinking about the changing place of Islamic law within a kind of oil economy in the aftermath of oil wealth, right? And so he's an intriguing figure. I mean, part of my interest in him stems from, well, the fact that he has this fatwa on Perling, which is deals with a question that elicited considerable debate in the sheikdoms in the 1910s and 1940s, when the Perling season that fell in the summer coincided with the month of Ramadan. And the question was, what are the diver ritual obligations when Ramadan falls in the summer? Can they continue diving? Should they interrupt the diving and go back and wait until the end of Ramadan and then return? So this is an interesting question for for three reasons. One is, it's one of the few issues where you actually have fatwas addressing dimensions of Perling. That's the first thing. So scholars were debating a range of questions during this time. Some of them had to do with international maritime law, who owns the sea, but questions about Perling specifically were rather restricted, and the ones I found, a lot of them have to do with this issue. So, the second interest of this debate about what are exactly the divers' ritual obligations during Ramadan, when the holy month falls during the diving season, is that this question actually led to broader debates about the Perling industry. What kind of an industry was it? And whether there were forms of usury and forms of labor coercion that characterized Perling, which made it suspicious, highly hierarchical industry, right? Where divers were the most vulnerable members, often enslaved, and who worked for the profit of a few powerful pearl merchants, Arab and Indian, right? But they were constantly indebted and so on. And so the only traces of a kind of critique from within religious scholarship regarding the pearling industry is found in these discussions, because in order to determine whether the divers were entitled to interrupt their fast while they are diving during the pearling season, jurists considered whether traveling to the pearl banks was legitimate in and of itself. If they were only traveling to pay off their debts, in an industry that was ridden with usury, with riba, then religious scholars sometimes felt that this was an occupation that should not be indulged. Now, Sheikh Abdullah bin Zayed al-Mahmoud that you mentioned has a very interesting fatwa, because he breaks a little bit of the dominant perspective on this issue. And he does that with an interesting mode of argumentation that makes the social location of the divers central to his argumentation. So he assumed that divers wanted to dive in order to earn a living. And he emphasized that earning a living in a lawful manner was a form of jihad, right? He uses these words. And therefore, one should encourage them and not only allow them to continue diving, but also encourage them to do so, right? And now in adopting this position, he was breaking with the dominant perspective, which prohibited diving, right? And you have some of his colleagues, even in Qatar, were very much against it. And so there is a lively discussion that emerges in the 1910s and in the 1940s. And I think in the 1940s, in a context where the pearling is already in crisis, this is a question that also divides the religious establishment between traditionalist scholars, madhab-based scholars who emphasize a very sharp distinction between the benefits of ritual practice of fasting during Ramadan over and against the illicit or illicit pursuit of economic gain, these mundane issues, versus an approach that reformist scholars like Sheikh Abdullah bin Zayed Al Mahmoud adopt, where both ritual practice and economic acts can be part of a broader category of worship, right? And should all be equally encouraged. And so my interest on Sheikh Abdullah bin Zayed comes from this particular fatwa. It's the fact that it's the only issue was intriguing, but it was understandable given the fact that there were other legal institutions in Qatar, right? Other families in Qatar dealt with the pearl trade. It was not the Al Mahmouds. Families, I mean, they have names. They are in Qatar. They were Al Husayris, Al Khulaifis, Al Hitmis, Al Muslimanis, Al Asulaitis, Al Jufairis. I mean, these were the families that provided the judges for the pearl trade, right? So there was this clear division of labor, and I think religious scholars actually they recognize this division of labor. But they also thought that Sharia could exercise a certain degree of moral oversight over activities in the pearl trade. So I guess the point that I'm trying to make is that the customary law and Islamic law in this particular moment were sometimes practically interrelated, but they were also conceptually distinct in the mind of these religious scholars, at least. Okay, so that's Abdullah bin Zayed as a figure in the pearl trade. I mean, he himself had studied in Qatar before he became the Qadi of the land in Sheikh Mohammed Abdulaziz Al Mania, who opened a school here. And he came to study and stayed with an uncle who was already engaged in the pearl trade. So perhaps he had a certain sensitivity to pearling that some of his colleagues did not have. Now he is a figure that looms large in Qatar's history for the reasons that you highlight. He slowly adjusted to the possibilities that modern state formation offered in order to establish a powerful Sharia judiciary, right? And my interest in him stems also from the fact that his archive is publicly available. So we have quite a bit of information about his fatwas, about his treatises, and about some of his legal decisions. So we can explore in some detail how a Qadi and Mufti operated in Qatar during the second half of the 20th century. He was, of course, much opposed by British authorities because he strongly resisted British encroachment and the establishment of these civil courts. And so in a sense, I think the history of the 20th century Sharia law is a history of the rise and fall of Sharia institutions in the country, right? So until the 1990s, Abdullah bin Zayed and his Sharia courts were able to operate more or less independently from the state. And then from the 1990s onwards, they became progressively integrated into the state apparatus, right? And ceased to exist as a separate institution. So anyone interested in the kind of modern history of Islamic law will need to look at the presidency of Sharia courts and the work of Sheikh Abdullah bin Zayed Al Mahmoud, who features so prominently within this.
Okay, thank you very much. I've got all kinds of follow-up questions, which I'm just going to keep to myself. But I remember when I was reading your paper about this fatwa, I thought, well, this is not how he is remembered as issuing a fatwa that I think had Habib Bourguiba would have loved to have had that kind of authority behind him back in the 1960s when he tried to make a political version of a similar kind of argument. So there's something just fascinating about that particular fatwa, but about this figure. But I'm going to stop asking questions because I've already seen some appearing in the chat window. I'm going to actually hand things over here now to Shana Marshall, who's the Associate Director of the Institute for Middle East Studies, to moderate the questions from a very considerable audience.
Thank you, Nathan. I'm going to keep my image off just to direct all the energy into the audio so that you can hear me clearly. So we have a lot of great questions. Thank you so much for the discussion. I'm going to go ahead and give you the questions in order. I'll start with two, if that's okay. Right? Okay. Do you know of any parallels for the Salafia loans or the advances system that exist in other regions or in other economic systems? And then a second question, was the Kuwaiti Constitution a result of British pressure on the Emir of Kuwait?
Okay, so the first question, I mentioned, I was speaking about the Salafia court, right, as a legal forum where pearling disputes were adjudicated. This is a legal forum that has a particular history. I think it becomes increasingly marginalized in the course of the 20th century for a number of reasons. Some have to do with British pressure. Others have simply to do with the, I think, growing integration of the pearl trade into global structures of capitalism, which force or prompt questions that Salafia judges are unequipped to answer. The question that you mentioned is more specifically about the Salaf, right? The Salafiyya, the advances that boat captains would give to their divers as a form of binding them to work for them for the during the pearling season, right? And this is why pearl diving was often considered a form of indented labor, because in order to pay off their debts, the divers worked for boat captains year in and year out, and sometimes after they passed away, their children, their sons, would take up the father's jobs and work in order to pay off their father's debts. Now there are parallels to this. I mean, even in the fishing industries in the Arabian Peninsula, right, which were less seasonal than the diving industry, it was common for boat captains to lend money to their fishermen in the off seasons. We have Sargent has written a number of studies about agriculture and fishing activities in the Arabian Peninsula. I think his evidence comes from, he studies places like Yemen and also Bahrain, and he offers very interesting laws and descriptions of how these trades worked. And so the fact that a boat captain would take responsibility and for the sailors during and outside of the working season was apparently commonly practiced, not only in the diving industry, but also elsewhere. The second question has to do with the Kuwaiti Constitution. And I think what the questioner means is the Qawanin al-Haws or Qanun al-Hawasin, I think it's called, the rules of divers, And these laws, I mean, this is the second law passed by the Constitutional Council in Kuwait. It's not the first law of pearling that we have. So in 1918, the British actually wrote down the laws of the pearl trade as they applied across the sheikdoms, with some attention towards local variation. Right, and so this is a very useful document, right? 1918, which probably does not speak about the industry in the 19th century, but gives us a kind of counterpoint to the laws that were passed in Kuwait later on, and we can see some of the evolution. I think I'm not sure about British pressure, but I think there is definitely kind of the imperatives of nation building that are already present in the Kuwaiti laws, right? So there's a logic towards nation building that is maybe partly related to the British colonial presence, which undergirds the Kuwaiti codification of pearling laws. So, for example, jurisdictional spaces are much more clearly defined in the Kuwaiti laws. So there's no role whatsoever for Islamic judges, whereas in the past, Islamic judges featured in a limited but in a nevertheless important way in the proceedings of the Khalifa court. They were called upon to administer oaths when plaintiffs could not agree, and also to distribute the inheritance shares of the deceased sailors. Now, so this points to a kind of jurisdictional fluidity that lasted until the first decades of the 20th century. The Kuwaiti law abolishes that, right? The Kuwaiti law abolishes any role for any independent state, independent legal authority other than the state body, the Constitutional Council that had been created. So I think I hope I'm answering that question about Kuwaiti Constitution. It's not the Constitution itself. It's more specifically regarding the Kuwaiti codification of pearling laws, which is often referred to as a reference point in discussions all over the Gulf, actually, by Qatari historians, as well as a kind of reference for understanding what the pearling laws were like.
Yes, I think that gets to the questioner's main point, what they were asking about. There is this issue of jurisdictional fluidity. There's a few questions that relate to that specifically. One is, could you reflect on the extent and the ways in which laws and rules affecting the pearling industry or maritime law more broadly, as we move further into the 20th century, were shaped by the Islamic legal tradition and or British law, and how you saw the interaction of these legal traditions on a jurisprudential level? And then there's this related question: if we're talking about sheikdoms and polities as the principal way in which law was organized, what does the juridical field actually look like? Meaning, are we talking about a system of legal pluralism? Are these different pockets of law and jurisdiction just separate from one another, and what groups them together?
Okay, thank you for this. I mean, these are great questions, and I mean, so what does one mean by law, right? What does law look like, and what do you feel? So for me, law refers to the space where conflicts are settled, either through appeals to external norms, Islamic or customary or otherwise, or through sovereign decisions. So this for me is this field of law, and in British archives, there's a lot of talk about the Emir's court or the diving court or the Sharia court, but these were very weakly legal forums, right? So the Khalifa judge, I mean, we know from oral history that the Khalifa judge in the 1920s in Bahrain would settle conflicts in the coffee shop in Muharraq, and the Sharia judges, they would issue verdicts while walking or sometimes in their own homes. So we need to think about a legal space that is very weakly institutionalized and where there are multiple forums, right, for dispute resolution. And so Perling, I think, is interesting because it shows how there is a specific forum that is that one would assume is the default mode of dispute resolution, the Khalifa court. But there are also multiple ways of circumventing it, right? Because, I mean, so a powerful pearl merchant who is in a conflict with a boat captain will go directly to the emir, right? Rather than the Khalifa court, because the Khalifa judge's allegiances cannot be determined in advance, and so the merchants, they hope that they can draw on their social and economic capital with the emir in order to achieve a more beneficial outcome. Likewise, we see that actors also can rely on Islamic courts, and there are some cases, some famous cases that end up being adjudicated in the Sharia court. I mean, in addition to the British legal courts that can be used as a last resort, both in the Gulf, so the political agencies, but also in India, right? So since the 18th century, there are cases in the mayor's court in Bombay where pearl traders from the Gulf that pearl traders from the Gulf resort to. So there is a fluidity with a very uncertain jurisdictional boundaries, right? And there is no attempt really to clarify and to settle these boundaries before the British come in, right? And I think the British lead efforts to to render the legal field more tied to territorial notions and imposing a conception of political sovereignty that is often a fiction because emirs do not control the tribes, the pearling tribes or other tribes that are the object of these conflicts. But nevertheless, the British start to imposing a set of rules that end up creating, I think, a modern understanding of territory and political sovereignty that are fictions originally, but become realities over the course of the 20th century. So law, I mean, I think we need to think of law in this fluid manner where it is often, there's an expression that I like by a German scholar, Frauke Herdbay, where she says law is more often requested than enforced. So it's a space of negotiation, right? And that takes multiple forms. And so for us as scholars, I think the task is to be able to think about the jurisdictional jockeying that actors engage in, right? And how they exercise legal agency by navigating from one legal forum to another, right? This is the kind of language that draws on Lauren Benton's work, but I think that's a very fruitful way of thinking about the fluidity of the legal field.
Great. Thank you. Yeah, we have lots of questions, so I'll move on to two more related questions. How did the trans-regional character of the pearl trade influence Gulf societies and polities? And then could you say something about the role of slavery in pearling and the effect that that had on Qatari religion and culture?
Okay. Well, so the trans-regional character of the pearl trade. I mean, I think this is a fascinating issue, right? Because we know that the pearl trade, from a number of works that some of the scholars are here, was directly towards India. And India, Bombay in particular, from the mid-19th century onwards, becomes not only the economic center for the pearl trade, but also a kind of cultural, religious, intellectual hub. It is a little bit ironic that the British sought to exile the troublemakers in the Gulf to India, because it is in India that they would become politicized and that they would, first of all, form a kind of Arab community of merchants that that was very much aware of issues of empire and resistance, and was also in alliance with the kind of anti-colonial movement in India in the 20th century. So there are some fascinating stories about people like Abdullah Zayani in Bahrain, who pearl merchant and religious scholar, right? Who had been to India and had become politicized in India, and who in Bahrain was expelled because he opposed the abdication of Sheikh Isa al-Khalifa. And the ruling family in Bahrain tried to intervene and have him sent to Iraq because he had studied in Iraq. There's also a long-standing connection between religious scholars in the Gulf and in Iraq. But Abdullah Zayani opposed that. Even though his wife was Iraqi, he wanted to be sent to Bombay. And when he arrives in Bombay, he's received by Ali Jinnah, by Shaukat Ali, by even a representative of Nehru. And he establishes a number of alliances with the anti-colonial dies quickly. So the consequences of his exile in Bombay cannot be certain, but he had chosen Bombay because he wanted to use British legal institutions in order to contest the decisions of the political agency in Bahrain to exile him. Right. So India, I think, plays a very important role in the pearl trade and at all these levels, right? Economic, political, and religious. New ideas about Islam also start to circulate. I mean, from the late 19th century, from the last quarter of the 19th century onwards, these journals, Arabic journals, are being read in the Gulf, in the saloons, majlises, and of the notables. These journals come either from students of religion that are in Al-Azhar, or from pearl merchants in Bombay. Right, so Yusuf al-Qinai, for example, who is a famous figure in the kind of Islamic reform movement in Kuwait, he receives his copy of Al-Manar, published in Egypt, from his brother, who's a pearl trader in Bombay. Right? So Bombay becomes, I think, a very interesting place for the elaboration of new ideas, new political, religious, and social ideas that are eventually taken up in the Gulf, the course of the 20th century primarily. Question about slavery, right? So what role? So we know, I mean, there's a very good work by Matthew Hopper that looks into this. The manumission certificates of these enslaved pearl divers offer very interesting information, partly about the ways in which they sought to navigate the legal pluralist structures of the chiefdoms during this period, and partly on the oppressions, but also the opportunities that divers, enslaved and afterwards freed divers had. So they were a significant population. I mean, I think the main insight from this secondary scholarship is that the pearl boom that started in 1860s, fueled by the demand for pearls from Europe and North America, stimulated an increasing number of slaves from East Africa, right? And so in Bahrain, in the 1920s, British agents say that almost all the diving population is foreign. They specify that this does not mean slaves or enslaved or freed Africans. It can also mean foreigners from Baluchistan and other areas. But they played a very important role. Did it have an effect on Qatari religion and culture? There's very little scholarship on this. I think, I mean, perhaps it is to literature that one must turn in order to find answers about this question. There's been a number of books that look at fictional works, novels. Muhammad Ali Ibrahim in Kuwait, in Qatar, has written a book about this. And I think the idea is that there were certain religious practices associated with these enslaved divers, right? And some of these are captured still in the songs that pearl divers sang. And there's a number of studies of those. Some of those are their own religious practices, like zar ceremonies, right, which is a ritual of exorcism, jinn exorcism, that was conducted mostly by these enslaved populations, but I think had a certain kind of Islamic legitimacy also, even though that was contested. So this is the information that we have. Zar as a kind of heterodox religious practice performed mostly by enslaved divers and free divers of African descent, which has continued, right? Until recently. Nowadays in the Gulf, these practices are regulated by the ministries of Awqaf, right? That identify the scholars and provide the phone numbers of scholars who can legitimately exorcise demons and jinns. But some of these roots have, some of these practices have roots in the enslaved divers.
Wonderful, thank you. That's really fascinating. I'll move on to next round of questions. Could you tell us more about the Khalifa court? That they rule based on custom raises the question of what constitutes custom here and who gets to make claims about what that custom looks like. That's one question. The second question, could you expand on nation building in Kuwait or the development of democratic constitutionalism in the Gulf?
Mm-hmm. Okay. So Khalifa courts, right? And and to what extent are these courts governed by customary laws, right? I think the question is hinting at the fact that the distinction between customary and Islamic law has a troubled history, right? It's a colonial invention. This is at least has been suggested, has been argued in the relevant in the relevant scholarship. Now, so it's a complex question. I want to say that the question is complex because in some cases these judges, right? So I'm still working on this, but the judges who officiated in the Khalifa court, they were pearl merchants by trade, and they were chosen because of their familiarity with the trade rather than their knowledge of the Sharia. Nevertheless, these pearl traders were often the people who also had the most advanced religious instruction in the Gulf, right? Sometimes they were the same people, right? Muhammad bin Hassan al-Marzuqi, for example, in Qatar. He wrote, he's known for writing refutations of An-Nabhani, right? A kind of critic of Wahhabism. But he's also published a book for Mukhtasar Daftar Hisab al-Lulu, a book for measuring and evaluating the value of pearls in Bombay, right? So he was both a religious scholar and a pearl merchant. And so these people are everywhere. Now, I think, so I concede to the point that the distinction is a troubled one between customary law and religious law. Nevertheless, when one reads the writings of religious scholars about the pearl trade, there is a sense in which for these religious scholars, pearling is a different activity governed by a different set of rules, right? So they recognize the limits of their own expertise. They recognize the necessity for having specific knowledgeable people of experience in the trade to adjudicate cases. And they criticize some of the practices in the industry, practices that they find to be usurious and practices that they find to disadvantage the divers. So if you read religious scholarship, I think the impression is that there is some form of this distinction that is made, at least by these religious scholars, right, between the customary laws that govern the pearl trade and Islamic law as a kind of overarching moral framework. Right? There is more to say about this, and I think I'd be happy to continue the discussion about like the relationship between pearling laws and Islamic laws. I mean, over time in the in the course of the 20th century, it is in religious schools that the mathematical skills that are necessary to distribute inheritance shares according to Islamic law and to calculate the value of pearls are taught, right? So there are all sorts of course, connections, right? Institutional and practical between the pearling laws and Islamic laws. But I think from the perspective of religious scholars, it was nevertheless possible to distinguish between the two and to use the Sharia as a resource to critique practices and laws within the pearl trade. Okay, so the other question was about constitutional developments in Kuwait and the Gulf democratic constitutionalism. I mean, yeah, I think this is a very fascinating story that has not been told yet. I mean, there's some work by Omar al-Shahabi, for example, that highlights some of these connections between the pearl trade and the nascent democratic aspirations of an emerging nationalist movement in Bahrain. I think this story is a story that is not only about the Gulf, but also involves anti-colonial networks that span the Indian Ocean, and where the anti-colonial movement in India played a very important role. There might be people here who are more knowledgeable about this than I am, and I mean, that's an interest of mine to think about the ways in which the pearl trade was central to the reconfiguration of religious knowledge in the Gulf, but also political imaginaries. Partly because pearl merchants were so well connected. They were connected that they had very extensive trade and religious networks to the Arab world, right? So Damascus, Baghdad, the Hijaz, Cairo, but also to India, and in particular Bombay and Calcutta to some extent. So this is, I mean, if some of you might want to take this up, because I think there is material in Arabic to tell this history. There might be some records from the British India Office on the Arab merchant community in Bombay that might also shed some light on this issue.
Great. I think we have time for one last question, which is perfect, and that'll put us right at 1:15. And this is also a request for your guidance on sort of offering additional reading for the folks on the Zoom today. So your discussion on trans-regional solidarities is fascinating. Is there a literature you suggest for further reading? How does one study these broader histories when national archives may constrain or limit this perspective?
Well, so thank you for this question. I mean, there are different sorts of trans-regional solidarities here. I mean, some of them are like directed towards the Arab world, and these are particularly present in the religious scholarship that I'm looking at, where it is clear that pearl merchants and religious scholars were very well connected to the kind of heartlands of the Arab world. In terms of scholarship, I think Ahmed Shamsi's book, Rediscovering the Islamic Classics, talks a little bit about this in the context of the Arabian Peninsula, looks at these Arab, the connections within the Arab world of kind of reformist Islamic discourses, where texts circulate for printing, and some of them are mediated by pearl merchants who have access to the publishing houses of Bombay. I mean, one of my students, Rima Sada, has written a wonderful thesis also about the role that Sheikh Jassim Al-Thani the founding Sheikh of Qatar, also played in the circulation of reformist and Wahhabi ideas in the late 19th and early 20th century. And Sheikh Jassim was in contact with scholars in the Arab world, but also with publishing houses in India. That's how he could, by drawing on British mail, escape Ottoman censorship and smuggle Wahhabi tracts into Ottoman Baghdad and Damascus. Now, the other sort of trans-regional solidarities have to do with India, right? And have to do with Bombay. And I think the material there is available. Well, there are references, of course. Most studies, I mean, many studies, Nelida Fukaro, for example, and other studies that refer to the kind of 20th century histories of the Gulf mention the pearl trade and mention the centrality of Bombay for economic and also political aspirations. There's not a lot of detail in these works. I think for more detail, there are archives that are available. And so, first of all, the Arabic historiographies of pearling often include letters from pearl merchants who spent time in Bombay, right? The Ali Ibrahim, for example, in Kuwait, or Zayani in Bahrain. Their families have made available a number of archives that include some of the letters that tell the picture of the ways in which these solidarities were shaped and consolidated in the course of the 20th century. I think my understanding from Sahib Alam, who's a historian who might be here, an Indian historian working here in Qatar, is that the India Office archives that are kept in Bombay and in Delhi also contain much more information about the Arab merchant communities in Bombay during the first half of the 20th century than the India Office archives that are kept in the British Library. And so, unfortunately, I have not been able to travel to New Delhi or Bombay yet, but I hope to look into that. But then maybe some of you who have access to these materials can also start exploring. There's also things in the Urdu media, Urdu newspapers, about the participation of Arab merchants in the Khalifa movement, into pan-Islamic networks, into anti-colonial projects. That it needs to be looked at. So I think there are possibilities there that need to be tapped into.
Thank you so much, Alex. We'll have to have you back when you write that book to have another discussion with us. Thanks, everyone, so much. Thank you so much, Alex, for this really extremely insightful, even to someone who doesn't study this topic specifically. Thank you also so much, Nathan, for engaging in the conversation. Thank you to all of our attendees for your wonderful questions. In the chat, there is a link to the YouTube page where the recording of the conversation will be posted soon. Thanks, everyone, for your attendance. And please join me in giving a muted but heartfelt hand to Alex for joining us late in the evening on his end. Thank you so much, and we hope to see you guys back here for our next event.
Thank you, Shannon. Much appreciated.
Thank you, Nathan. Thank you, Alex, so much for your wonderful discussion today. And just a reminder that our next event is actually the annual conference on producing the Middle East, looking at media, and that's the March 25 and March 26th, followed by a lecture with Jennifer Durr, and that's on April 15th. So hope you'll be able to join us for those. Thanks so much.